May it please the Court, Justice Cheki, Justice Matopo, I am Sinan Reserve, and I appear on behalf of the first and second applicants, Mr. and Mrs. Van Wyk, as well as the third applicant, Sonke Gender Justice.
May it please the Court, Justice Cheki, Justice Matopa, I appear on behalf of the Minister of Labour and Employment in both case 308 and as respondent, and case 309 as the first respondent.
Thank you. Is that all concerning Van Wyk? Let me proceed with the hand down. Today, the Constitutional Court hands down judgment in application for confirmation of the order of constitutional invalidity by the High Court of South Africa, Gauteng Division, Johannesburg, and on application for leave to appeal against part of the order of the said court. In the first application, the first and second applicants are Mr. Werner Van Wyk and Mrs. Erga Van Wyk, a married couple. The third applicant is Sonke Gender Justice, in brackets Sonke. The fourth applicant is the Commission for Gender Equality, in brackets the Commission. The respondent is the Minister of Employment and Labour, in brackets the Minister. In the second application, the Commission is the first applicant and Sonke is the second applicant. The first respondent is the Minister. The second and third respondents are the Van Wyks. For convenience, the two applications have been consolidated because they seek similar orders. The Minister has filed a notice to abide the decision of this court in both applications, but has filed written submissions to assist this court in its determination of the matters. There are 5 entities who are admitted as amici curiae, in brackets friends of the court. They are the Center for Human Rights of the University of Pretoria, Solidarity Center South Africa, the International Lawyers Assisting Workers Network, the Labour Research Service, and the Center for Child Law. They advance arguments in support of the applicant's criticism of the Basic Conditions of Employment Act, in brackets BCEA, and the corresponding sections of the Unemployment Insurance Act, in brackets UIF Act. The court is grateful to all the amici for their submissions. The applicants seek to confirm an order of the High Court to the effect that Section 25, 25 capital A, 25 capital B, and 25 capital C of the BCEA, dealing with maternity and parental leave, together with the corresponding sections 24, 26 capital A, 27, and 29 capital A of the UIF Act are inconsistent with the Constitution in that they provide greater benefits to biological mothers than to every other category of parents, notable fathers. The unfairness and the unconstitutionality of the provisions came into focus when Mr. Van Wyk approached his employer seeking 4 months consecutive paternity leave. Mrs. Van Wyk was and still is in business for her own account. Mr. and Mrs. Van Wyk agreed with each other before the birth of their son that Mr. Van Wyk would assume primary responsibility for taking care of their son as soon as possible after the birth, since Mrs. Van Wyk had 2 businesses to run. When Mr. Van Wyk approached his employer with the request for paternity leave, he was informed that he was only eligible for 10 days parental leave. Mr. Van Wyk decided to take his unpaid leave of 6 months in order to care for his son. Aggrieved, the Van Wyks, along with Sonke, approached the High Court for an order declaring Section 25 of the BCEA to be invalid and inconsistent with the Constitution, and for the declaration to be suspended for a period of 24 months from the date of declaration to allow Parliament to correct the defects. the Commission brought an application to intervene as a fourth applicant, challenging the provisions on similar grounds, specifically focusing on adoptive and commissioning parents in a surrogate agreement. An order joining the Commission was duly granted. The former minister defended both applications. The constitutional challenge rested on 3 grounds, namely that A, the differentiation between mothers and fathers in Section 25 of the BCEA serves no legitimate governmental purpose and is irrational. B, if indeed serves any legitimate government purpose, it nevertheless amounts to unfair discrimination with no justification. And Section 25 of the BCA is in any event offensive to the dignity of parents, as it prescribes the manner in which families may be legitimately structured, and it deprives parents of their fundamental choice of how they may nurture their own children. The High Court found that it was evident that there was differentiation between birth mothers and other parents in the impugned provisions of the BCEA, specifically regarding the duration of entitled leave. The court found that the differentiation between fathers and mothers amounted to unfair discrimination. It held that it is unfair for the mother to be deemed the primary caregiver when the burden of childcare should be equally shared with the father, considering that parenting is unique in nature. The court found that all mothers in all parenting categories should be entitled to the same period of leave if inequality is to be avoided. It further held that the minister had failed to articulate a legitimate governmental purpose for the differentiation in the impugned provisions and to plead material facts to show justification for the discrimination. The High Court thus made a declaration of constitutional invalidity with a reading in to safeguard the rights of parents and children during the 2-year suspension period. In this court, the applicants seek to confirm the order that the impugned provisions are inconsistent with the Constitution on the basis that they discriminate unfairly between categories of parents and their children and are in violation of the equality and human dignity rights as entrenched in Section 9 and 10 of the Constitution. In a unanimous judgment penned by myself, this court holds that the matter does engage this court's jurisdiction, as Sections 167, Sub 5, and 172, Sub 2 of the Constitution mandates this court to consider orders of invalidity made by other courts. The minister accepts that the provisions are inconsistent with the Constitution and further accepts that there is a need to reform the parental leave regime contained in the BCAA. She states that her team is presently focusing on the necessary reforms to the legislation as expeditiously as possible. This court finds that the discrimination caused by the impugned provisions is unfair and unconstitutional. The protection of birth mothers to the exclusion of other parents has the unfortunate consequence of perpetrating the assumption that women are and should be the primary caregivers of children. The father is marginalized
Thank you. I hand down the judgment. On Wednesday, the 30th July 2025, this court had an application for direct access on an urgent basis. In the main, the applicants, Mr. Jacob Zuma, the former president of the Republic of South Africa, and Umkhonto Wesizwe, the MK party, sought to challenge 3 decisions made by the first respondent, the President of the Republic of South Africa, on the 13th July 2025. The application arose from a series of serious allegations made by Lieutenant General Nhlanhla Mkhwanazi, the KwaZulu-Natal Provincial Police Commissioner, during a media briefing on the 6th July 2025. General Mkhwanazi alleged the existence of a sophisticated criminal syndicate that had infiltrated law enforcement, intelligence structures, and the judiciary, with specific allegations implicating the second respondent, the erstwhile Minister of Police, Mr. Senzo Mchunu, in interference with police investigations. In response, the President announced 3 decisions, placing Minister Mchunu on leave of absence, establishing a judicial commission of inquiry chaired by former acting Deputy Chief Justice Mbuyiseli Madlanga, and appointing Professor Firoz Kachalia as acting Minister of Police. Former President Jacob Zuma and the Umkhonto Wesizwe party challenged these decisions as constitutionally impermissible and irrational. They argued that the President lacked express constitutional authority to place a minister on leave of absence, that Professor Kachalia's appointment contravened the Constitution because he was neither a cabinet member nor a member of Parliament, and that a judicial commission of inquiry chaired by a judge to investigate allegations implicating the judiciary itself violated constitutional principles of separation of powers. The applicants claim these decisions demonstrated bias and favoritism. The President and Minister Mchunu opposed the application, arguing that the President possessed implied constitutional powers to place ministers on leave of absence, and that his decisions were rational responses to serious allegations requiring investigations. They contended that Professor Kachalia's appointment would follow proper constitutional procedures, and that the former acting Deputy Chief Justice Madlanga's appointment raised no reasonable apprehension of bias. The applicant sought to invoke both this court's exclusive jurisdiction under Section 167, subsection 4E, and alternatively direct access under Section 167(6)A of the Constitution. On the 31st July 2025, this court made the following order. I quote, "The Constitutional Court has considered the application for exclusive and direct access. It has concluded that the application does not engage this court's exclusive jurisdiction, and no case for direct access has been made out." And it made the following order. 1, direct access is refused. 2, costs are reserved. 3, reasons for this order shall be given at a later stage. These are the reasons. In a unanimous judgment penned by myself, this court finds that the threshold for determination is whether this court has exclusive jurisdiction to entertain the applicant's challenge, and if not, whether direct access should be granted. This required the court to examine what the applicants have pleaded in their founding papers. it is well established that jurisdiction is determined on the basis of the pleadings and not on the substantive merits of the case. What emerges from a careful reading of the founding papers is a case that challenges the lawfulness of specific decision that the President has made. What is notably absent, however, is anything more than a broad allegation that the President has failed to comply with specific constitutional obligations. The founding affidavit is scant and devoid of material evidence to sustain a claim of this court's exclusive jurisdiction. The Constitution distinguishes disputes related to the conduct of the President from those where he has failed to fulfill a constitutional obligation. Section 1674E must be narrowly and restrictively construed. The distinction between exercising constitutional powers and failing to fulfill constitutional obligation is crucial. Section 1674E addresses only the latter category. While when the President exercises a power, even if that exercise is challenged as improper, the inquiry concerns a positive act rather than an omission or failure. President-specific constitutional obligations are readily identifiable by their mandatory character. Provisions that provide that the President must act in specified circumstances. A failure to perform any of these mandatory President-specific obligation would engage this court's exclusive jurisdiction. However, sections like Section 84(2) and other provisions confer discretionary powers on the President using permissible language that indicates that the President may exercise those powers. The applicant's complaint in this case is not that the President failed to exercise his powers, but rather that he exercised them irrationally or ultra vires, in other words, beyond his powers. Such complaints concern the matter or the manner of exercising constitutional powers and not the failure to fulfill constitutional obligations and fall within the standard review jurisdiction of the High Court. The applicant's reliance on Section 83B of the Constitution is therefore insufficient on its own to ground this court's exclusive jurisdiction. Applying the principle established in EFF 1, this court finds that Section 83B must be coupled with a specific constitutional obligation in respect of which there has been a failure. No such agent-specific obligation is identified in this case. The broad approach taken by the applicants to the issue of exclusive jurisdiction without sufficient averments in the pleadings to make out a case is legally untenable. The applicant's complaint is the manner in which the President has dealt with the revelations made by Lieutenant General Mkhwanazi. Thus, none of the impugned decision constitute a failure by the President to fulfill his constitutional obligations. Having determined that this court exclusive jurisdiction is not engaged, this court proceeded to consider the alternative ground of direct access under Section 167(6)(a) of the Constitution. It is tried that this court grants direct access only in exceptional circumstances and if it is in the interest of justice to grant it. Applying established principle, this court finds that several considerations militate against granting direct access in this matter. First, the novelty and the importance of the issues raised favor initial consideration by the High Court. Second, there is no agency that necessitates this court sitting as a court of first and last instance. Third, although a High Court declaration that the President has acted unconstitutionally would require confirmation by this court to be effective, Section 167, subsection 2b of the Constitution empowers the High Court to grant interim relief pending confirmation. The applicants have not adequately explained why they did not pursue this available avenue. The fact that appellate or confirmation proceedings might follow a High Court's judgment cannot undermine what the Constitution says about the proper allocation of jurisdiction. The importance of issues in a case do not without more constitute exceptional circumstances and justify this court being a court of first and last instance. The more important and complex the issue in a case, the more compelling the need for this court to be assisted by the views of another court. In the result, the application cannot succeed on either threshold. This is not a matter that falls within this court's exclusive jurisdiction under Section 1674E of the Constitution, nor is it one where the interests of justice favor direct access under Section 1676A of the Constitution. Accordingly, it is not competent for this court to opine on the merits of the applicant's challenge to the impugned decisions, and that issue must be left for the right time and at the appropriate forum should the applicants be so inclined. On the question of cost, I find that although the applicant's case for exclusive jurisdiction and direct access is unsuccessful, the constitutional questions they sought to raise were not entirely without merit. The jurisdictional claims, though sufficiently pleaded, are not so manifestly hopeless as to warrant costs. Biowatch protection is that warranted in the circumstances, and each party should bear their own cost. I hand down the judgment.
As the court pleases.
Oh,
As the court pleases.
the court adjourned.